Frustrated with your online search results? Call Reputation Defender today to join tens of thousands who've improved their online reputation. Get your free reputation report card at reputationdefender.com or call 1-877-866-8555.
I'm John Morgan of Morgan & Morgan. With so many mesothelioma lawyers on television, how do you choose the right firm for you and your family? Our goal is to get you as much as you deserve. $30 billion was set aside for mesothelioma victims like you. If you've been diagnosed with mesothelioma, we'll come to you within 24 hours so our team can get to work right away. Call us now. There's only one Morgan & Morgan.
Call 800-649-9090.
Good morning, 11 a.m. Eastern, 8 a.m. Pacific. I'm Jose Díaz-Balart. We begin this very busy hour with breaking news from the Supreme Court. In a major 8-1 decision, the court upheld a statute that bars people subjected to domestic violence restraining orders from having guns. Joining us now, NBC News Washington correspondent Yamiche Alcindor. Yamiche, good morning. Break this down for us, if you would.
Well, this is the Supreme Court saying that there are limits to the Second Amendment. And in this case, if you are somebody who is found in violation of domestic violence laws and who have a domestic violence restraining order, that you can temporarily have your firearms and access to firearms to be taken away from you. I think it's interesting here because, as you said, it's an 8-1 opinion. You talk a lot about the Supreme Court being a 6-3 conservative majority. But here in this case, you had liberals and conservatives on the same side, with Chief Justice John Roberts writing the majority opinion here. The one, of course, dissenter is Justice Clarence Thomas. I want to read to you a little bit of, or just explain to you a little bit out of his dissent. He said at one point that this law taking away guns from domestic violence abusers, that it violates the Second Amendment, and that the history and tradition of this country is that we didn't have domestic violence laws taking those guns away, and as a result, that should not be taken away. He also said that this lacks due process for the people who are who would be losing access to their guns. That being said, you heard from a number of concurring opinions here, including Justice Kagan and Sotomayor, who say it doesn't really matter if in the beginning of this country you had laws that were protecting abusive husbands and not protecting their wives, that should not be the way forward. You have Ketanji Brown Jackson saying that the justices need to be mindful of the way that the laws are playing out in real life. And you have Amy Coney Barrett saying specifically the Second Amendment is not absolute. I also want to read to you a bit of a statement from Attorney General Merrick Garland, who is now weighing in. He says in part, the Justice Department will continue to enforce this important statute, which for nearly 30 years has helped to protect victims and survivors of domestic violence from their abusers, and we will continue to deploy all available resources to support law enforcement, prosecutors, courts, and victim advocates to address the pervasive problem of domestic violence. And if I could, Jose, I just want to also just remind people who brought this case. His name is Zaki Rahimi. He is someone who was violating domestic violence laws and was convicted of that at one point. He is someone who also, his ex-partner said at one point, allegedly assaulted her, dragged her across the ground, fired a shot in the direction of a witness, and also was implicated in a series of other shootings. So the Supreme Court was weighing in specifically on his access to guns, saying that he, given his history, should not have access to guns, and others who have similar history should also not have access to guns, Jose.
And you meet 21 of June, and we're still waiting for a number of key cases to come out from the Supreme Court. What are you watching for?
That's right. There are a number of cases still pending before the Supreme Court. The big one, of course, is that Trump immunity case, with former President Trump claiming that he has absolute immunity to criminal prosecution, saying, in fact, that he really should not be allowed to be prosecuted for any sort of crimes, one done under the official acts of being president. We also have another case dealing with abortion. It's whether or not Idaho's near total abortion ban, whether or not it trumps federal law that requires that people have emergency medical care. It's related to a law called EMTALA. So we're waiting for a number of cases. There's also a case dealing with homelessness and whether or not a law in Oregon there that says that people can't camp out outside, whether or not that's cruel and unusual punishment. So definitely a lot of cases, but as I said, that big case we're looking for is the Trump immunity case. Jose?
Yamiche Alcindor, right outside the Supreme Court. Thank you, my friend. Really appreciate it. And with us now to continue our conversation, Katie Phang, attorney and host of the Katie Phang Show here on MSNBC, and Paul Butler, former federal prosecutor and MSNBC legal analyst. So, Paul, just your reaction to this case that was announced today in an 8-1 decision.
The court support for gun rights is not unconditional. Jose, this is a common sense decision. Mr. Rahimi beat up his girlfriend and said he would shoot her if she told anybody. So she appropriately got a restraining order that suspended his license to carry a gun. That didn't stop him. He threatened another woman with a gun. He shot off his gun in public places 5 different times, including once when his friend's credit card got declined at a fast food restaurant. So during oral argument, even the conservative justices were like, this man should not be walking around armed and dangerous. The question was, how legally did the court reach that result, given its very expansive interpretation of the Second Amendment? So 8 justices found a way, or actually several different ways, which explains why there are 3 different opinions in support of the result, in addition to Justice Thomas's dissent.
Yeah, I mean, Katie, reading through some of the concurring opinions, and of course, then Clarence Thomas's one dissent. Tell me about what 8-1 tells you, and then what is this really reaffirming a precedent, or is this specifically something that is tailored to one specific type of incident? Seems like it could be both, right? So I love your last question, Jose, because it really creates the framing for how all of us should be looking at this particular decision. As you mentioned, the bump stock decision just came out 1 week ago. And when we saw that, it seemed like there were absolutes. There were lines in the sand that were being drawn to protect the Second Amendment from the Supreme Court. But when you see an 8-1 decision, it gives you cause for pause, because it makes you kind of question this whole kind of ideological battle that we think is going on in the halls of the, revered Supreme Court. But then when you look at something like the dissent from Justice Thomas, he is speaking in absolutes. Clarence Thomas is saying that the Second Amendment is reverent and you cannot touch it in any way. And absolute. And so he obviously is the lone dissent. But the reason why it creates conflict, Jose, and the reason why this is just going to be the beginning of a series of what could be inconsistent opinions from the highest court in our land, is you look at the language in the majority opinion that was drafted by Chief Justice Roberts. He actually uses the phrase common sense. And my esteemed colleague, Paul Butler, just talked about how this is a common sense decision. And this is the collision that you and I talk about all the time, Jose, which is how much ground do we cede to common sense? How much ground does the Supreme Court cede to the development of time and the evolution of principles and ideas? Of course, somebody like this man, Rahimi, should not have his hands on a weapon. But according to Clarence Thomas, because the Second Amendment is an absolute constitutional right, it can never be infringed in any way. But the majority opinion and the concurrences make it clear that because, quote, the precedents were not meant to suggest a law trapped in amber. That says to us, Jose, that there should be differing opinions that come out depending upon the facts in a case. But it's concerning, Jose, because the Supreme Court doesn't take any and all Second Amendment challenges, do they? They don't. They're very selective about what they grant cert. They pick and choose what they want. And so depending upon the facts of a case, depending upon how the case made it to the Supreme Court, in this instance, it came from the Fifth Circuit, which we know is historically very conservative in terms of its decisions. That is the Fifth Circuit that gave us the Mifid-Pristone decision and other very kind of challenging and controversial decisions. Depending upon how that case makes it to the doorsteps of SCOTUS, and we talked about this last week with bump stocks, that is how we end up having the precedent. And so I see a very deep divide, actually, in SCOTUS that is not just on ideological grounds, but how do we, as Supreme Court justices, interpret precedent? Yeah, and Paul, but I want to ask you this first, Katie. So there's the Coney Barrett and her explanation of things. There certainly is a change, or a difference there between obviously how she perceives it and how Thomas perceives it, right? Is that kind of what you're talking about? And then add, like, what I was fascinated by Katani Jackson's, she says, we should also be mindful of how its legal standards are actually playing out in real life. And that's so important, because these decisions don't live in a vacuum. These decisions from the highest corner of the land control how you and I live our lives, and all Americans do, because that is the final say in a legal courtroom, is what a Supreme Court decision is. And so all the lower courts across the United States are bound by those decisions. These are not decisions in a vacuum. Rahimi getting his hands on a firearm is a recipe for disaster. It is literally a bomb waiting to go off.
off or a gun waiting to fire. And so that is why when you look at somebody like Clarence Thomas or other decisions that seem to fly in the face of common sense, it makes you wonder, what is the purpose of the Supreme Court anymore? What is the reason why this place exists with lifetime appointed justices that make rules and laws that end up binding all of us to what they decide to be? And I think, again, you're going to see, you had November 7th, 2023 oral arguments. We're sitting here in June, the end of June of 2024. Right. The reason why it took so long is you see all of the majority opinion, the concurrences, and the dissent. This is lengthy. It's 103 pages all in, Jose, for what it is. But I'm sure, as you're going to speak to Paul about this, it's important for people to understand that we have to live by these decisions, Jose. And so when you see something like this, it could have been it could have been a 6-3 flip, like we've seen, where maybe they said, you know what, you can't infringe on the Second Amendment in any way. But doesn't that ignore reality? There was no Second Amendment back in the colonial days. So this kind of ignores reality of what's going on right now.
And Paul, just your final thoughts on this. Do you think that this is the reaffirmation of precedent, or is this in any way setting up any new ground?
It's pushing back on precedent, especially Justice Thomas's opinion in the Bruin case a couple of years ago, where he said that for any gun regulation to survive a Second Amendment challenge, it has to fall within the history and tradition of firearm regulation. Justice Jackson really comes for Justice Thomas in her concurring opinion. She points out domestic violence wasn't even recognized as a crime until relatively recently, so it's not going to be something that the court could look to 1700 or 1800 and figure out what the law was on it then. So there's an exception apparently created today to that original analysis if someone with a gun is a danger to others. But as you pointed out, last week, the court allowed basically anybody who wants to have a machine gun to have one. And again, that's a person who also potentially could be a danger. So I think what we're seeing is the court struggling with this conservative Second Amendment ideology versus public safety and common sense. And the court still hasn't come up with a way to reconcile those two tensions.
Katie Fang and Paul Butler, thank you very much. Stay with us if you would. Up next, we're going to go live to Florida, where a hearing is underway right now in former President Trump's classified documents case. What's happening there so far? There's a lot of activity there. Plus, campaign cash. New reporting on the money both President Biden and Trump are bringing in and why the former president's coffers are filling up fast. And we'll talk to a White House official about its new nationwide effort on reproductive rights 2 years after the Supreme Court overturned Roe v. Wade. We're back in 90 seconds. You're watching Jose Díaz-Balart Reports on MSNBC.